Hello and welcome back to course 103 Rural Society and Polity in India, Unit 3 Village India, its Political Structure, Lesson 2 the 73rd Amendment Act and the provisions it makes for having a Panchayati Raj system in rural India. In Lesson 2, the present lesson, we will cover what is contained in the 73rd Amendment Act and the mandate it sets out for Panchayati Raj. The structure of the lesson is to first understand the purpose of the 73rd Amendment Act, to know about the salient features of the 73rd Amendment Act. We will also look at some of the key terms that are defined in this Act, and lastly, we will cover different articles of the Act and what are the specific provisions under each of these articles. The 73rd Amendment Act calls for local self-governance in India. Likewise, the 74th Constitutional Amendment Act was also passed, which introduces local self-governance in urban India. The acts came into force as the Constitutional 73rd Amendment Act of 1992 for rural areas, which actually came into effect on 24th April in 1993. And the Constitutional 74th Amendment Act of 1992 came into effect on 1st June 1993. Both these amendments added two new parts to the Constitution of India. The 73rd Amendment added Part 9, which was titled Panchayats for rural local bodies, and the 74th Amendment Act added Part 9A titled Municipalities for urban local bodies. Both these acts are attempts to recognize the third level of India's federal democracy. The Panchayat Raj system, as outlined in the 73rd Amendment Act, also recognized as a form of direct democracy, that is, powers of government are directly exercised by the common people, and there is stakeholder involvement in decision making at the village level, and there is a devolution and decentralization of power to grassroots level. The preamble to the 73rd Amendment Act identified Panchayati Raj institutions as self-governing institutions, and it gave them constitutional status. The 73rd Amendment Act puts forward a three-tier PRI structure as a mandatory pattern across all the states in India. Likewise, the 74th Constitutional Amendment Act, which is for urban local bodies, calls for a three-tier structure in urban areas. So, in contemporary times, what we see the form of rural local self-governance is as per the 73rd Amendment Act and its provisions. The 73rd Amendment Act essentially implements Article 40 of the Directive Principles of State Policy. Even in Lesson 1, we highlighted what the Article 40 says. I will highlight that again. State shall take steps to organize village panchayats and endow them with such power and authority as may be necessary to enable them to function as units of self-government. In the Constitution, local self-government, Panchayati Raj, was a state subject earlier, which means that states were free to make their own laws on this subject, and the central government could not pass any legislation concerning them. This, however, changed with the 73rd Amendment Act. Panchayati Raj was put on the concurrent list. That is, both centre and state had the power to make or revise laws pertaining to it. With this act coming into effect, states were required to either make a fresh or new act or to bring an amendment or revise the existing acts that they had. And this was done so that all the state acts were in conformity and in tune with the 73rd Amendment Act. And this was to be done by all the states within a period of 1 year, that is from 24th April 1993 to the next year, that is 1994, and it directed all the states to also implement the system. Karnataka was the first state to bring in the new legislation, and other states followed like Gujarat, Bihar, Tripura, Sikkim, Odisha, Madhya Pradesh, and Tamil Nadu also introduced the Tamil Nadu Panchayat Act in 1994. And by 23rd April 1994, which is a year later, all states and union territories had passed legislations in order to conform to this constitutional requirement or this amendment act. In 2004, the Ministry of Panchayati Raj was formed. Now, given the increasing importance of the Panchayat Raj system, a need was felt and a new ministry was formed. The basic role of the ministry is to ensure that there is inclusive development and that there is efficient delivery of services at local level. It monitors the implementation of the 73rd Amendment Act, and also to make sure that Panchayat Raj institutions secure economic empowerment and social justice for their populace. It also funds research studies, workshops, seminars for development of panchayats. The Ministry of Panchayati Raj keeps record of the state Panchayati Raj acts, the state or the union territory Panchayati Raj acts. It also keeps a note of the status of elections of Panchayati Raj institutions, state-wise as well as union territory-wise, when were the last panchayat elections held and when are the next elections due. In addition, there are also circulars and guidelines that are issued by the ministry time and again, and best practices are also highlighted and promoted by the Ministry of Panchayati Raj. The National Panchayati Raj Divas is observed on April 24th. The Ministry of Panchayati Raj celebrated it on this day because this is the day when the 73rd Amendment Act came into force in 93, and since 2010 actually it is being celebrated on this day. But the most significant change that the 73rd Amendment Act has brought out is the constitutional recognition that it has given to elected local representatives and to adult franchise, that is the right, adult franchise essentially meaning the right to vote by all above 18. And the institutions of self-government came to be seen in their own right and not just as mere administrative extensions of the state or the union government. Now let us see what all does the 73rd Amendment Act provide for. A three-tier system of panchayats at the village, intermediate, block, which translates to the block, taluk or the mandal level, and then the district level. States with populations of less than 20 lakhs have an option not to introduce the intermediate level. The constitution and the composition of the panchayats was left to the states, but all the seats were to be filled by elected persons from the respective panchayat territory. The basic unit, the Gram Sabhas, that is all the village adult members who are registered as voters. And when we say universal adult franchise, consists of persons registered in the electoral rolls relating to a village or villages within the area of the panchayat, and the seats are to be filled by direct elections. In addition, the Act also provides for and calls for affirmative action, that is reservation. So seats are reserved at all levels in every panchayat for scheduled caste and scheduled tribe in proportion to their population, and such seats may be allotted by rotation to different constituencies in a panchayat. 1/3 of the total seats are to be reserved for women, that is not less than 1/3 should be for women. And the seats that are reserved for scheduled caste and scheduled tribe, even among those, 1/3 has to be reserved for women. And these seats reserved for women may also be allotted by rotation to different constituencies in a panchayat. As far as reservation for other backward classes is concerned, that is left to the discretion of the states. Let me give an example. So if in a Gram Panchayat there are to be 10 elected members, the reservation for women would effectively mean 1/3 equals to about 3 seats. And these, how many seats, if for instance within a Gram Panchayat there is more than one village, so how many of these 3 seats would be reserved from which village or constituency of the Panchayat, that is something that can be decided. And if we take scheduled caste, scheduled tribe reservation as per the population to be 3 seats, so even within these 3 seats, 1/3 has to be for women, so which will translate to effectively 1 seat of SC, ST for a woman. The term of each Panchayat is to be for a period of 5 years. The elections for the next Panchayat are supposed to happen before the expiry of this 5-year term. In case there is an event of dissolution of the Panchayat, then the elections are to be held within a period of 6 months. And courts are not supposed to interfere in electoral matters of the Panchayats. And with these election provisions, there is a continuity of Panchayats that has been ensured. What is the role of Panchayats? Their role is to prepare plans for economic development and social justice on subjects as are given to them by law. Additionally, an independent election commission is also to be constituted by each state, which will look after the control of electoral rolls, and it will supervise and direct the elections. Now, where do Panchayats get finances from? The sources of funds could be any of these. It could be budgetary allocation from the state government, it could be share of revenue of certain taxes, then the collection and retention of revenue that Panchayat itself raises, some funds from the central government programs and grants, also from the grants given by Union Finance Commission. In each state, a state finance commission is also supposed to be set up once in every 5 years, and the role of the state finance commission is to determine the principles, basis of which adequate funding and financial resource can be ensured for the Panchayat. So the 73rd Amendment Act, like it was mentioned earlier, added Part 9 to the Constitution, and the Part 9 pertaining to rural Panchayats contains Articles 243 and Articles 243A to 243O. Article 243 defines various terms. Let us have a look at the terms that are given here. District. District simply means district in a state. Gram Sabha means a body consisting of persons registered in the electoral rolls of a village or villages which fall within the area of the Panchayat. Intermediate level, that is the level between the village and the district, which is specified by the governor of a state by public notification. Panchayat means an institution of self-government under Article 243B for rural areas. Panchayat area means territorial area of a Panchayat. Population defined as the population as per the last preceding census, of which the relevant figures have been published. Village means a village specified by the governor, again by a public notification, and it could also include a group of villages as specified. Moving further, let's look at some other articles and what do they specify and provide for. Article 243A. Under Article 243A, a Gram Sabha is empowered to exercise powers and perform functions at village level as provided by law. Article 243C says that the legislature of a state is empowered to make provisions for the composition of the Panchayat, and the Panchayat area will be divided into territorial constituencies, and the state is empowered to provide for representation of the chairpersons of the Gram Panchayat at the village, intermediate or district levels. and the chairperson of Gram Panchayat is to be elected in a manner that is provided by law. Article 243G mandates the preparation of plans in order to deliver economic development and social justice, the preparation of the Gram Panchayat development plan, and to deliver schemes or programs for the same objectives. Article 243J, the legislature of a state is empowered to make provisions with respect to the maintenance and auditing of accounts of the panchayats. Article 243L provisions that Part 9 of the Constitution should also apply for the union territories. Article 243O, courts are barred from interfering in electoral matters. So, for instance, in allotment of seats to constituencies or questioning the election of a panchayat. The election to any panchayat can actually be questioned only by an election petition, and as is mandated and provided by law of the state legislature. As required under Part 9 of the Constitution, all the states and union territories have enacted or amended their Panchayati Raj Acts to incorporate the provisions, and states have also had the liberty to take their geographical, their historical, political, administrative context into account when adopting the Panchayat Raj system. There are, however, some exceptions, and the exceptions are applicable to the following areas: the entire states of Nagaland, Meghalaya and Mizoram, hill areas in the state of Manipur. The district level provisions do not apply to the hill areas of the district of Darjeeling in West Bengal, which affect the Darjeeling Gorkha Hill Council, and the reservation provisions are not applicable to the state of Arunachal Pradesh. We see these exceptions in the map. To conclude, I will leave you with an activity in the form of a question. Do you think constitutional provision is required to see effective functioning of panchayats in India? What if they did not have a constitutional provision? How would that affect their existence and working? Write a small one-page note. I conclude.